Welcome to WG University, Weber Gallagher's series of educational programs. This is our workers' compensation webinar series. I am Cheryl Benosa, and I am presenting today with Vanessa Mendelewski from our Mount Laurel office. If you'd like to view this webinar again, share it with others, or see our other WG University programs, please visit the Weber Gallagher website at www.wglaw.com, and you will find copies of this presentation and others under the WG University page. Also, please feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is Who is an Independent Contractor? Let's get started.
First, we'll start with a discussion as to who is covered in New Jersey workers' compensation. New Jersey workers' compensation covers all employees who are injured in the course and scope of their employment, as long as the injury arises out of their employment. Section 36 of the workers' compensation statute specifically defines who is an employee. It's someone who performs services for financial consideration. Now, before we get into who is not an employee, meaning who's an independent contractor, we'll discuss some defenses to the workers' compensation claim real quickly. So there's some common defenses to the workers' comp claims. The injury didn't arise out of the employment. The injury did not occur in the course of employment. The injury was idiopathic in nature, meaning it had nothing to do with the employment, it just occurred spontaneously. The injury was not timely reported. The injured worker was intoxicated, and the injured worker is an independent contractor. This last point is what we'll be discussing today. An independent contractor is not defined by the statute. We look to the case law for this definition, and this is a very fact-specific area of the law. So we'll actually review two cases today. The first case is a case where the workers' compensation judge found the injured worker was not an employee, and the appellate division agreed that they were not an employee, but an independent contractor. This first case was actually decided in August of 2015. It's Baybaker versus XYZ two-way radio. A couple of key facts in this case are that the injured worker was a limo driver. He was providing chauffeur services to XYZ, which is a car limo service. He had been involved in a motor vehicle accident October 21st, 2011. And this injured worker actually worked between 10 to 12 hours a day, 6 days a week. He was able to pick and choose the days that he worked, as well as the hours he worked. So he could work a full 10 hours, 12 hours, or possibly even less. He also had the option to not work at all for any given period of time. Now, the drivers for XYZ, including the injured worker, used their own car and paid their own insurance. The drivers were not reimbursed for gas or any other expenses. And the fares were paid by the passengers to XYZ, and then XYZ paid the drivers a percentage of the fares for the individuals that they transported. The drivers then received a 1099 form to submit for their taxes at the end of a given year. In this particular case, the judge reviewed all of the facts and found that the injured worker was not an employee. He was an independent contractor. The case was appealed, and the appellate division agreed with the workers' compensation judge. They looked to the case of Kotskova to evaluate the factors to consider in determining who is an independent contractor. Now, there are 12 factors, so we'll go through all of them to briefly explain, but in Baybaker, the court really only focused on two of the factors. The first one is the employer's right to control the means and manner of the worker's performance. Did they specifically tell them how they had to do the job, how it had to be completed, when it had to be completed? Second factor is the kind of occupation. Is it something that can be supervised or unsupervised? The third factor is the skill used to complete that job. The fourth factor is who furnishes the equipment and the workplace. Is it something done by the company for the person, or does the injured worker provide all of the tools that are used to complete the job? The fifth factor deals with the length of time the individual has worked. The sixth is the method of payment, such as cash, check, and so on. Factor number 7 is the manner of terminating the work relationship. Does one party get to terminate? Do both parties terminate? And factor 8, is there any annual leave? Factor number 9, whether the worker is an integral part of the business of the employer. Now, when looking at this factor, the courts also look to see whether the injured worker is economically dependent on that relationship. So factor number 9 is kind of a two-part test that the court looks at. Factor number 10 is whether the worker accrued any retirement benefits during their work for the company. Factor 11 is whether the employer pays Social Security taxes, the employer meaning the company they work for. And number 12 is the intention of the parties. Did they intend to have an employer-employee relationship or not? Now, in this case, the appellate court looked at those 12 factors and found that XYZ exercised very little control. In this particular case, the injured worker had the ability to reject or accept fares, and if he rejected the fares, he would go to the bottom of their list. So they did not control the fares that the injured worker took. He himself controlled them. The appellate court also found there was no risk in limiting the number of hours, and he couldn't be terminated if he decided to work less than the number of hours, 10, 12. If he decided to work a 5-hour day, they couldn't fire him for just working 5 hours. And after working for XYZ for 23 years, he had no salary or wage. He was paid by 1099, and what he was paid, again, is based on the percentage of the fare. The passengers paid XYZ. XYZ gave a percentage of the fare to the petitioner or the injured worker. They also found that he was not an integral part to the business, as XYZ was not dependent on any one driver. They could use many drivers to reach their client base. Now, in this particular case, they focus, again, on factors 1, the control. Did XYZ have a lot of control? And factor number 9, whether they were an integral part of the business. So the court really looked at those 2 factors in this particular case. Now, the next case we're going to talk about, the court actually found something a little different, and Cheryl is going to speak about that.
Yeah, so this case was obviously different from the case that Vanessa was discussing. The workers' comp judge actually found that the cab driver was an independent contractor, but the petitioner did appeal, and the appellate division overturned the decision of the workers' comp judge. In Pendola versus Milenio Express Incorporated, doing business as Classic, it was a decision that was decided on October 26, 2018, and it is unpublished. The facts of that case is the injured worker was a driver for the respondent, and he fractured his ankle in 2014 while picking up a customer in Newark. He worked exclusively for the respondent from 2003. He was required to paint his taxi cab silver. He was required to affix the company logo on the sides and the front of the vehicle, and he was required to buy a 2-way radio. He was also required to pay for his medallion, gas, and maintenance for his car. Now, the employer provided business cards, receipts, and vouchers, and it had the employer's name on all. The injured worker was only permitted to pick up passengers dispatched through the employer, and he did not receive a 1099 form. He was required to pay the employer $150 per week as a dispatch fee, and the employer had rules that the drivers needed to follow. Now, if the driver failed to follow these rules, the driver would be suspended. Now, in looking at these facts, the workers' comp judge ruled that the petitioner was not an employee. He had stated that the taxi had to be silver with the company logo and phone number, which was required by the taxi division. He also stated that Newark had assigned the color of the taxi. The injured worker was free to accept or reject fares dispatched by the employer. The employer did not pay the driver's salary, and the driver had to pay a dispatching fee of $150. The employer was not dependent on the driver, since there were other drivers available if he was not available for the fare. So after the finding of the workers' comp judge, on appeal, the petitioner argued that the workers' comp judge underestimated the degree of control the employer exercised over its drivers. He also argued that the judge misconstrued the economic dependence of the driver upon the employer's business and the relationship of the nature of his work to the operation of the business. Now, the appellate division, they reversed and remanded, and the finding that the injured worker was an employee. So their reasoning included 3 factors that should be considered in determining an independent contractor. The first is employer control. The second is the worker's economic dependence on the work relationship. And 3, the degree to which there has been a functional integration of the employer's business with that of the person doing the work at issue. The courts applied the facts and found that the injured worker had been working for the employer for 11 years, that this job was his sole source of income, that the employer exhibited control over the drivers with its requirement of the 2-way radio, its rules that the employer would enforce concerning the dispatched passengers, the condition of the cars, and not being able to pick up the competitors' dispatched passengers. The employer was also dependent on the driver and other drivers like him to operate a successful business 24 hours a day.
Now, the key points to take away from this discussion today would be that the facts of each claim are very, very important. So that all the facts will be applied to the independent contractor test on a case-by-case basis. And it seems that the courts look at the right of the employer or the company to control the work, also the economic dependence of the injured worker on the company, and whether the injured worker is an integral part of the company's day-to-day business. Those seem to be the 3 main factors the court typically looks at, but they do weigh the other factors. Now, this can sometimes come into consideration when you're dealing with Uber or Lyft drivers, right?
Yes, I mean, they look like they could be employees, but they are in fact independent contractors. Lyft and Uber, they emphasize the independence and flexibility of their drivers. They can choose their own schedules. They drive their own vehicles. As such, they would probably be classified as an independent contractor.
And there are situations where, I don't know if you've seen, but I've seen sometimes in the city or in surrounding areas, people that actually have Uber stickers and Lyft stickers on their cars, so they can switch between the two, making them independent contractors because they're not solely reliant upon Uber or Lyft, one company. So that's very much the consideration with the courts. So that is the end of our presentation for today. If there are any questions, they can be sent to us.
Yes, thank you for attending our webinar, Who is an Independent Contractor? You can learn more about this program and all other Weber Gallagher events at www.wglaw.com/WG-University.
Thank you for attending today's webinar.